Good afternoon, Judge Kathree Setiloane.
Good afternoon, Chief Justice.
How are you this afternoon?
Very well, thank you, but you can imagine, very nervous.
Well, I don't know what you say, I can imagine, because you are very used to that seat.
Yes, I've become a veteran at this, but it's always a daunting experience. I mean, there's a wealth of wisdom in this room, like I've said before.
Okay, now we will start. Thank you very much for availing yourself for consideration for appointment to the Supreme Court of Appeal. You already know the procedure here. I will ask you questions, and then the Deputy President of the Supreme Court of Appeal will ask you questions, and the Minister, and then commissioners will also ask you. We'll try by all means to bear in mind the selection criteria that we have adopted as a commission in asking you questions. So we are going to start. Your academic qualifications are BA, LLB, and LLM, is that right?
Yes, Chief Justice.
Yes,
Correct.
and you got them respectively from the University of Natal, and Georgetown University.
Yes, my LLM from Georgetown University.
Yeah, the LLM is from Georgetown. And you started your pupillage, was it in the mid-90s, or it was around 1996?
1995, 1996, yeah. I can't.
Yes. And you were appointed...
1996, you're quite right, yes.
96. You were appointed as a judge in 2010.
Yes, October 2010.
Yeah, so you have been a judge now for about 13 years?
Yes, 13 years, and I was an acting judge for about a year before that.
Yes. And you have acted in a number of courts. You have acted in the Labor Appeal Court, you have acted in the Competition Appeal Court, you have acted in the Constitutional Court, you have acted in the Supreme Court of Appeal.
Yes, Chief Justice.
I don't know whether you've acted in the Land Claims Court as well.
No, I didn't act in the land claims.
But all the others that I've mentioned,
yes.
I'm right.
Yes, all the appellate courts I've acted in.
Yes.
You're quite right.
And I would imagine that you have been exposed to all these different branches of law in terms of the experience you gained through acting.
Yes, I'm very fortunate to have been invited to act in those courts and to have sat for some time in those courts.
Yes.
And I've had the opportunity to be exposed to areas of the law that extend beyond the law which we deal with in the High Court, I suppose.
Yes. In the Constitutional Court, were you there for 2 terms or more than 2 terms?
For 2 terms.
Yes. Mm-hmm. And in the Supreme Court of Appeal, how many stints have you had, and how long were the stints?
I first acted in 2016 for 6 months, and I was invited. Thank you to Deputy President Petse, who's here today. I was invited again at the end of last year. So I've been there since the 1st of December, appointed on the 1st of December, and I will continue to sit till the end of this year.
Yes.
Yes.
Yes. And in all these courts in which you have acted, have you been able to produce reported judgments?
Yes, Chief Justice. I have produced in excess of, I think, 62, 63, it may be up to 65 reported judgments in all of these courts.
Yes. And the 2 acting stints that you have had in the Supreme Court of Appeal, how have you found acting in that court?
Oh, I've thoroughly enjoyed it.
Yes.
Thoroughly enjoyed it. I enjoyed my first experience there back in 2016, and I've enjoyed this experience since the beginning of this year even more. It is an absolute pleasure to sit in the court. It is such an organized court. You know exactly what's required of you, you know, what your allocations are, what your tasks are. You learn from the senior judges in that court, which is really wonderful, you know, to kind of work having the guidance of the senior judges and the junior judges that have been there now for some time. You know, for them to guide you in the process. And they're wonderful people that serve in the Supreme Court of Appeal. Over this last year, I've made some friends and some very good friends. And, you know, I hope that I can actually be part of that court and to be able to make a contribution to that court. The collegiality is just unbelievable in that court. You know, you would think where one sits in an appellate court and you are dealing with highly contentious areas of the law, and you have all of these differing views from members of the panel, but I haven't had any, you know, aggression. I never had any bad experiences with the judges there. If I wish to dissent in a judgment, or if I wish to write a minority judgment, or if I wish to basically bring my, you know, sort of add my view to the scribe's judgment. So I haven't felt any resistance, and I feel that at the end of the day we all work as a team with the guidance, of course, of the presiding judge. Yes.
Yes. And of course, when you were acting in the Constitutional Court, you would have had exposure to dealing with a lot of constitutional cases, is that right?
Yes. Some were pure constitutional cases. Other matters were matters that dealt with important points of law.
Yes.
Yes.
Yes. Did you get a chance either while acting in the Constitutional Court or in the High Court or Supreme Court of Appeal or in any of the courts in which you have acted to deal with a case where you were required to decide whether legislation was inconsistent with the Constitution and therefore invalid?
Yes, I've dealt with one or two cases, a few cases actually,
Yes.
where we had to decide whether the legislation was inconsistent with the Constitution, and we declared it unconstitutional, or found that it wasn't constitutional. I think there was the McBride matter that I sat in. There was the case pertaining to the 2,000 to 4,000 residents in buildings downtown that were basically removed from their homes in the middle of the night by the police on the basis of a warrantless search. And we found that provision of the Police Act to be unconstitutional. There was the Contingency Fees Act. There was a constitutional challenge to that came before us some years ago. And we found that that provision wasn't unconstitutional.
Are you able to share with the commissioners what you look for when you consider whether legislation should be declared inconsistent with the Constitution?
Yeah,
and invalid? How you go about, what you look at, what you look for?
Okay. I mean, I think one needs to look at the provision that's being challenged, the impugned provision. One needs to interpret that provision, and one needs to interpret that provision purposefully in the context of the Act as a whole. One needs to interpret the right that is infringed. One needs to, given the lapse in the many of the years now, the Constitutional Court has basically given content to most of the rights in the Bill of Rights. So you look at the rights, you look at how it's been interpreted. You don't just look at it literally for what it is and what it says in the Constitution, but when you're interpreting the rights in the Constitution, you must actually look at the whole value system of the Constitution. You must then, of course, look at the provision, the impugned provision, and see to the extent to which it infringes the right in the Constitution. And then one also has to then do a limitations analysis, and integral to the limitations analysis is the proportionality of the infringement and the reasonableness of the provision. One needs to look at the legislative purpose behind that legislative provision, and one also needs to look at whether it is the least restrictive means of actually achieving that legislative purpose. So it's an interpretive process, and then you've got to assess it against the constitutional right, and then you've got to do a limitations analysis. And of course, also, you've got to also look at all of this, like the Constitutional Court has said, through the prism of Section 39, one of the Constitution. And when interpreting legislation and developing the common law, one has to have regard to the spirit, purport, and objects of the Bill of Rights.
Thank you. There are two types of discretions. Do you want to share with the Commission if that is in law? Maybe there is a third one. But the common ones, I think there are two. Do you want to share with the commissioners what they are and what the differences are about them, or the legal significance of the differences between the two?
Okay. Well, I always get confused with the terminology here, so just forgive me if I get them wrong in terms of the terminology, but I know what they are. Yeah. So there's the narrow discretion, and there's a wide discretion. And I think that the distinction lies in the standard, or the distinction basically dictates the extent to which, or the standard of interference, basically, by an appellate court.
Thank you.
Do you wish for me to go further? Well, if you want, insofar as the distinction.
Well, if your answer was not complete, you can complete it.
And I think it's important. There's very little scope for interference by an appellate court. Appellate court will seldom, basically, interfere with the exercise of a discretion, unless, if it's a narrow discretion, unless, you've got to look at whether the High Court basically exercised the decision judicially, or whether it was influenced by wrong principles, or an incorrect assessment of the facts, or for some other reason the decision is so unreasonable that it doesn't accord with our understanding of the facts and the circumstances of the case as a whole. In relation to the wide discretion, the decision maker has a choice of options or variables, and the decision maker can choose from any of those options or variables. And a court can really only interfere with that choice if the option adopted by the High Court is at odds with the law. I mean, I think this is important because it's important for comity of the courts, it's important for finality of the judgments, and for certainty, finality of the law and for certainty of the law. I think I'm finished now. Thank you.
Thank you. I will now give the opportunity to the Deputy President of the SCA.
Thank you, Chief Justice.
Thank you, Chief Justice. Good afternoon, Judge Kathree Setiloane.
Good afternoon, Deputy President Petse.
You have already told this commission that you acted at the SCA 2016, and you have been there again since the 1st of December 2022.
Yes.
And you have a handful of judgments in the SCA to cover those periods?
Yes, yes.
I had occasion to be part of your three previous interviews when you were interviewed for the position of the Constitutional Court, and your name ultimately featured in the list of names which were sent to the President in terms of Section 174, subsection 4A.
Yes, Deputy President.
And on those three occasions, although you were being interviewed for the position in the Constitutional Court, I raised everything with you which I thought, needed to be explored with you. You still recall that?
Yes, I recall very clearly. And thank you for raising those issues with me, so I could give some clarity on them. Yes.
Thank you. And my parting shot with you now is, unless, of course, you want to disagree with me, I may be wrong. If you were recommended for a position in the Court, which is the apex court, you should be equally up to the task, or even better, for the SCA, which is not the apex court. Yes,
Sorry, I'm here to be recommended for the SCA right now. I'm a bit confused by the question, sorry. You are saying if I were recommended for the Constitutional Court?
No, what I'm putting to you, you were recommended for appointment in the apex court.
Yes, yes.
And the SCA is not the apex court.
Yes, yes.
And you are now vying for a position to grace the bench of the SCA.
Yes.
Can you think of any reason that would disqualify you from ascending to the bench of the SCA?
Judge Petse, I can't see why I shouldn't be recommended for this court. I think with my experience on the bench, 13 years being a High Court judge, and my appellate experience, one hopes that the commissioners here today will basically recommend me for a position to the SCA. I would have applied earlier for the SCA, but I didn't feel that I was ready because I hadn't acted. I mean, there is a practice that you need to act for a fairly long time there before you can be recommended for appointment to that court. I am so happy, having returned to the SCA, I am so happy at the SCA that making application to be elevated to the Constitutional Court lies so far, far away from my mind right now. I feel like I've really found a place in the SCA where I could, where I'm satisfied and interested by the law that we are attempting to make in that court. And so there's no reason for me, to jump very quickly to try and apply for the Con-Court again. I am very happy here. And I would like to stay here and gain experience and make my contribution to this court if I can, or if I may.
Okay, then that's your wish or desire, but do you think that you possess the requisite attributes
Yes.
to serve in that court, given that it's a national appellate court?
Yes, Judge Petse, I think I have the necessary experience for the court. I think that I have the ability to write judgments at the level of which that court basically expects one to write. I think that I will fit in very well in that court. And I think that I can make a contribution to that court. Yes.
Thank you, Judge Kathree Setiloane. Thank you, Chief Justice.
Thank you. Minister?
Thank you very much, Chief Justice. I've got no question except to say that I was also present in the last interview. Thank you.
Thank you.
Thank you, Minister Mola.
Commissioner Nojesi.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner Najesi.
I'm just doing fairness to other candidates with these two questions. One, at the SCA, even at the Concord where you have acted, you sit as panels, as a panel, and in those panels, other members are expected to contribute, correct judgment, or make comments.
Yes, yes.
Is that acceptable?
Yes, they all do. They make substantive comments, and they make comments related to, syntax, grammar, all of those little things, yes.
Yes. And second, with regard to the role of presiding officers, do you regard presiding officers as one among equals or as sort of principals in the panels?
No, I think they are presiding judges, but they are one amongst equals. Yes.
Thank you.
Yes.
Thank you, Commissioner Nojesi. Commissioner Marumwahai.
Thank you very much, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner Marumaka.
I just want to ask you two questions. One is procedural, and the other one is more substantive. If you are sitting at the SCA and you are one of the two judges who receives an application for special leave to appeal, and you dismiss that application, apart from the litigant appealing to the High Court, is there any procedure that they might utilize at the Supreme Court of Appeal? If there is, what is the procedure and what are the requirements?
Yes, I think if they are unhappy with the refusal of the leave to appeal by the Supreme Court of Appeal, then they have another bite at the cherry, and they are then allowed in terms of Section 17(2)(f), I think, of the Superior Courts Act, to basically seek a reconsideration, and that reconsideration will go to the President of the Supreme Court of Appeal, and the President will have to apply her mind to whether or not that application should be granted. Of course, you need to show that there are exceptional circumstances for a reconsideration, and I think there are judgments of the Constitutional Court, and one judgment in particular that I was involved in, which is the leashing judgment, which basically sets out the test that needs to be applied. But it's exceptional circumstances that have to be shown. You have to demonstrate exceptional circumstances.
No, certainly. Thank you very much. Another question would be a little bit unfair if you don't remember the facts, because it's one of the judgments that you wrote. I saw the judgment on your questionnaire, but just citing that you have written it, it's not here. But I'm hoping that you do remember. But if you don't remember, it's fine, because this is not a test, right? I'm raising that judgment because it's an important judgment, and you got it spot on. And it is in an area of law where I think the Supreme Court of Appeal has been found lacking on that. It's pension law, right? It was the withholding of retirement benefits. I'm not sure you read the Makate judgment.
Yes, I do remember the judgment. I think it dealt with, the court had to interpret Section 30N of the Pensions Fund Act.
Yes. The question I want to ask is this. When a panel is sitting and considering any matter, and there are cases that the Supreme Court of Appeal have actually decided upon, what leeway do those judges have to disregard? I'm not here. You did not do that, but I've seen other judges disregarding the same judge, the other judgments of the same court in the same area. Why do we see that happening from the Supreme Court of Appeal?
I think you can't just willy-nilly ignore previous decisions of the Supreme Court of Appeal. You can only interfere with you can only criticize those judgments or go against those judgments if those judgments are clearly wrong, and you have to then demonstrate why those judgments are clearly wrong.
Thank you very much, Judge. Thank you very much, TJ.
Thank you.
Thank you. Commissioner Steinberg.
Good afternoon, Judge.
Good afternoon, Ms. Steinberg.
You clearly have an old and deep and commendable interest in transformative jurisprudence. It's occupied your mind for many years. I'm interested in what would your advice be to High Court judges in particular about how we develop a more transformational jurisprudence in our country? See, it seems to me we focus more on the demographics of the judiciary, which is one obviously key aspect of transformation. But the other is the jurisprudence itself. We're looking for a jurisprudence that addresses socioeconomic inequality, racial and gender inequality, etc. What's your advice to judges in that regard?
Yeah. I mean, I think one has to eat, sleep, live the Constitution. And, you know, I'm of the view that the Constitution infuses all areas of the law. So as a High Court judge, don't fall into the habit of compartmentalizing cases and saying, oh God, this is a pure contract law case, and the Constitution has no impact on that. So it's very important that you do your best, both in applying the law, both in probing issues that come up for determination, and when you're applying your mind to writing the judgment, to ensure that at the end of the day, there's this recognition that there's this broader piece of legislation that basically suffuses everything related to the law. And so I think it's very important at that early stage in the determination, well, in a life of a High Court judge, to actually start to have a feel, for the Constitution. And I mean, it's wonderful. When at the High Court, and I'm talking about a few years back, we had a tea club. And most of my colleagues from their tea club have now been elevated to the SCA or to the Constitutional Court. But we had such stimulating discussions in that tea club, and they weren't just about the narrow issues in the case, but they were about the broader constitutional impact that these cases would have. So I think one needs to start thinking beyond just the narrow issues that you're dealing with in the case. Clearly, you can't visit issues that have not been raised and are not issuably raised in a matter. But one needs to kind of have a feel for the Constitution, and one needs to infuse the value system of that Constitution into your job as a judge, I think, and central to that task of being a judge is judgment writing. And I think one has this broader knowledge and understanding of the law and how the constitutional basically plays into that, one can then produce better judgments. And it's important to have a substantive understanding of the Constitution. I mean, I think that really it plays an important role when one is dealing with cases relating to socio-economic rights. So it's not just the formal application of the Constitution and what it says, but have a substantive application. How can one use the law to change the lives or change society in a way? You'll obviously do it incrementally, small steps. You don't always get the right cases, to make this great big impact. But as you rise in the judiciary, those opportunities will come your way, I suppose.
Thank you.
Thank you, Ms. Steinberg.
Could I just follow up on this discussion, Chief Justice?
I'm sorry, you are done, Commissioner Steinberg. Okay, you want to follow up?
Yes.
Yeah, okay.
Justice Kathree Setiloane, I mean, this for me is very interesting, this idea that the Constitution infuses everything, particularly because now you're going to go to the Supreme Court of, well, if you are recommended, I shouldn't run ahead.
One hopes that I am, Mr. Nguke Toby.
No, I should not run ahead of myself. I'm just one of 23 or 22. I mean, so, because I think in the Supreme Court of Appeal, we can ask you about your judicial philosophy, because you are going to be laying principles of general application to be followed by the High Court judges. And you've said to us, well, the Constitution infuses everything, but the one critical area of the law that the Constitution is not infusing is contract and property and delict. And you can see the two divergent streams of law, one being developed by the Constitutional Court and another being developed by the Supreme Court of Appeal. And you can see resistance. In fact, this is not me saying that, it's Justice Froneman who says that often the Supreme Court of Appeal explicitly rejects constitutional direction from the Constitutional Court on contract. So I want you to give us something actually tangible about what you mean. And here, I think the last iteration of the conflict is Bidika, and the judgment by Justice Froneman, which is about, well, good faith, are you for it or against it? Constitutionalism, are you for it or against it? So what, in fact, are the judicial tools to infuse the Constitution so that it's foundational to contract? Because right now, it's actually the common law that is foundational to contract.
Yes.
Everywhere you go, the judges will repeatedly give you the mantra back. You go there to argue a constitutional case, what is the answer from the judges? No, pacta servanda sunt. I know, that's why I'm arguing the Constitution. You know, so it's very nice to go to conferences and to say the Constitution underlies everything. But our experiences day in and day out is that judges almost, their natural reflex is the common law.
Yes, but I think in the Biedika judgment, Judge Taron had basically said that Ubuntu plays an important role in the law of contract. And again, it's for the Constitutional Court to give us to provide that normative framework on how we actually infuse areas like contract and delict, etc., with the value system of the Constitution. So, I mean, it's also difficult. I mean, one has the habit of falling back on common law principles, but to the extent that the common law is lacking, one needs to basically see how one can develop it. I mean, in the context of, I'm just thinking in the context of delict.
No, let's just stick to contract for now, because that's a more tangible thing.
Yes.
It's not as abstract as delict.
Yes, yes.
I need to get a clear example of what you mean by this infusion, because my own experience is that judges inevitably take you back to the common law.
Yeah. I mean, I think if you look at some of those cases relating to National Credit Act and contracts between banks and homeowners, you know, I mean, I think.
No, but they will say that those are already developed by statute. I'm looking for judicial development.
Yes. I mean, I just think that it's one, of course, there's a contract, and you know, there are the terms of the contract. There's agreement between the parties in relation to what those terms are, and the relationship is basically guided by those terms in the agreement. But you know, there may be instances. I'm just thinking about many years ago when I was still in practice at the bar, and I think I was just a very, very junior advocate. I remember there was a private school that basically expelled a student for some flimsy reason. And I remember going into urgent court and arguing this matter. And, you know, I was raising all of these constitutional principles that she has a right to education. And I was told, no. You know, the contract says that if you have misbehaved in this particular manner, then you will be expelled instantly. And I think one could look at this young girl who was 17 years old. She was about to write her matric exam, and here was a private school that basically expelled her on the eve of her writing this exam. And the court should have there taken into account the fact that she was under 18 years old, that she had certain rights, and by the contract, by the terms of the contract, basically stating that she could be expelled for this flimsy reason, that contract was then in contravention of an important right for a young person, the right to education. I'm just thinking how practically you could actually apply provisions in the Bill of Rights.
Yeah, so the one way of doing it then is where contract infringes a right in the Bill of Rights, it
Yes.
should be struck down on that basis.
Well, I suppose, yeah, you could find that, I don't know whether it's going against public policy, but certainly there is a there would be an infringement of a right,
And the
an
problem I
important
have
right.
with public policy is that that's the common law.
Yeah, that is certainly the common law.
But I'm talking about the Constitution.
Yeah, so I'm saying in the case where this young person was expelled from school for this very flimsy reason, and even if it wasn't so flimsy, one should have had regard to that very important right and what it means to a young person and that young person's livelihood going forward. So perhaps, you know, the court could have taken that into account
Yes, well,
before
this is the
finding
last-
that the contract prevails.
This is the last follow-up on this. And because I thought that there's a promising start where contract infringes a right in the Bill of Rights, then that's the basis on which it can be invalidated.
Yes, I think you can invalidate it. Yes, I do. I believe you can invalidate it. And the court ought to have given consideration to that.
Thank you, Chief Justice.
Thank you. Commissioner Klaba.
No, thank you very much, and good afternoon, Judge Setiloane.
Good afternoon, Commissioner.
Thank you very much. I've been looking at the comments of the law bodies, and they all wrote glowingly about you. And you have been before this commission several times, and on one occasion, you were recommended. Besides me asking you a probing question, what do you want to tell us that you did not tell us in the last occasions?
The last 4 times.
The last 4 times you were before us. Thanks.
I suppose in the last 4 times that I was here, I was applying for the Constitutional Court, and there was a different test. And I suppose now it's the Supreme Court of Appeal. And I think, again, I think I've sufficiently matured in the judiciary to be elevated to that court. And I strongly, hope that I would be. I don't know what you mean by what should I tell you that I haven't told you before. I think I've been a veteran, and I have been quizzed on virtually everything relating to my career from its inception. If there's something specific.
Nothing. Good luck.
Thank you, sir. Thank you, sir.
Thank you, Commissioner Klaba. Commissioner Lucas.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Commissioner
And,
Lucas.
It's nice seeing you again.
Lovely seeing you too.
Yes, you are one of the faces that is quite becoming a usual face here. And I should say I always enjoy the way you respond to the probe of the commissioners.
Thank you, Commissioner.
Yeah, some of the elements of the question that I want to ask you have been asked before, because one of the responses that you gave earlier is that in whatever you do as the judiciary, you want to make sure that we give effect to the Constitution and possibly strive for a more equal society. That is what I will add, but also to address issues of discrimination. I've noticed that you have been actually bringing the case to court on issues of same-sex marriages. But in hindsight, if you think about it, in terms of the achievements, after that they've been now enacted, and also in our engagement with many people, we still find that there is a lot of discrimination. And even in the process of enacting the hate speech bill, one of the groupings that is really experiencing problems is the LGBTIQA. So I was just thinking, in your own imagination, and particularly since the religious community is also still not very comfortable with this specific issue, in your own are you convinced that at the time it was the correct step and the correct decision? And if you think now about it, what more can we do to make issues of LGBTIQA acceptable in some of the groupings that we interact with? Thank you.
Yes, Commissioner, thank you very much for the question. I mean, I think that, I think it was 2001, 2002, that the Constitutional Court decided that matter. And yes, I was one of the two counsel that were involved in the matter. It was, I was led by Danny Berger, SC. I think it was an important time, given the progression of the rights of the LGBT community, to basically, for the court to basically deal with the question of marital rights of LGBT people, and whether the legislation and the common law did not, in fact, infringe upon their rights and treat them differently. The legislature, through direction from the Constitutional Court, basically enacted the Civil Union Bill that went broader than just the rights of the LGBT community. But it was the right time, and we made, South Africa being a little country so far south, we made a big impression with that judgment, and that judgment was looked at by the courts and the highest courts in the lands of various countries that were also thereafter, and many years thereafter, had to look at the question of whether the right to marriage should be given to members of the LGBT community. So that piece of legislation was very important. I think without the challenge to the Marriage Act and the common law, we wouldn't have had that piece of legislation. But one needs to still accept and recognize that members of the LGBT community are basically victimized every day. They are a minority group, and they, particularly transgender individuals, suffer at the hands of broader society, in the sense that they are subject to violence in the areas that they live, in the schools that they attend. There needs to be a whole mindset change. So our Constitution is so forward-looking, our legislation is so forward-looking, but society has to also move forward with the changes in the law. So I think it's important that society be educated, and that education needs to happen from the time that we're very young. The education needs to happen particularly relating to gender-based violence, violence against members of the LGBT community. That education needs to happen at primary school level. And in time, you'll find you'll have a population that is more open to minority groups, such as members of the LGBT community, to basically live their lives free of violence and discrimination. Thank you.
Thank you, Commissioner Lucas. Commissioner Poswa Leratoli.
Thank you, CJ. Judge Kathree Setiloane, I understand that you are saying you are now focused on going to the Supreme Court of Appeals, but I just find it difficult to understand that you have applied 4 times to go to the Constitutional Court, and that now you are ready and willing to serve in the Supreme Court of Appeals. I'm not too sure how much committed you would be to do so, and whether it is not just a matter of it being a last resort.
Commissioner, thank you very much for your question. I think if I had the opportunity previously to apply to the Supreme Court of Appeal, I would have done so. And whenever I applied for the Constitutional Court, the thing that always worried me is that I would have liked to have gone through the Supreme Court of Appeal first. And now that I've been invited back to the Supreme Court of Appeal and I've amassed sufficient experience as a judge of that court in the last year and the previous time that I applied. Remember, the last time I was at the Supreme Court of Appeal was for a very short period of 6 months. And I truly believe that the Supreme Court is now the place for me. I have no ambitions right now to even consider going to the Constitutional Court. I would really like to get experience at the Supreme Court of Appeal, and I would have applied to that court if the situation was different and the path to applying was clearer, I think.
One more question, Chief Justice. So how important is judicial temperament in the dispensation of justice? How important is it?
Yeah, I think judicial temperament is a very important criteria. I have been criticized by this body in the past for not having the requisite temperament. I would like to state unequivocally that I do have the temperament for being a judge. There were certain errors that were made in the past. One must remember that Johannesburg Court is a very, very, very busy court. And as a judge in that court, you really have to be on top of your game. You have to be fully prepared for the hearings. You have to be able to, as a judge, streamline the issues, in a sense, cut to the chase, because you have so limited court time available to you. So very often, counsel think that they basically must set the pace of the hearing. And they think that because you're a junior judge or you're a women judge, they could set the pace. But very often, judges have to turn the tables and we have to say that this is how I see the matter, these are the issues, please address me. And if I'm wrong, tell me why I'm wrong. So I think that the court community, they see me as being a firm judge, but they also see me as a very fair judge. I do my best to give counsel every opportunity to basically argue their case fully, and I will then interrogate the issues with counsel, ask them the relevant questions, and in response, I expect them to persuade me on the merits of their case.
Thank you.
Thank you, Commissioner.
Thank you. I didn't see any hands from the commissioners on the virtual platform. I think we have come to the end of this interview. Thank you very much, Judge Kathree Setiloane, for availing yourself once again. You are now excused.
Thank you very much, Chief Justice.
Thank you.
Thank you.